Property was purchased by me by my money in the name of my son, which is the defendant number one. I got to know that my property has been disposed of. So I immediately went to the civil court and filed a civil suit for whether in this particular matter, should I have filed for a suit of cancellation of sale deed or my suit of declaration is enough. Supreme Court explains in no uncertain terms of when to file a suit of cancellation of sale deed and when to file a suit of declaration. Supreme Court also says that there is one more thing. If B is in possession and is only seeking declaration, then no ad valorem court fees will be paid. But suppose B is also not in possession, but he wants possession, then he will have to seek consequential relief of possession and will have to pay the ad valorem court fees. Number one, I am in the possession. I have pleaded it in my plaint. I am only seeking for a declaration that this sale deed is invalid or non-est because it is my property. And the relief that I am seeking is the effect of the impugned order may kindly be stayed by this honorable court until the final disposal of this revision, and the civil suit should stay, should continue to operate, continue to ongo. My lord, by way of this civil revision, I am taking an exception to Annexure P1, which is an order passed by the Learned Civil Court on 10th of November 2025, wherein on the application preferred by the defendants under Order 7, Rule 11 for the payment of adequate ad valorem court fees by the plaintiff, the court has allowed that application of the defendant and has directed me to pay the ad valorem court fees. I am before your lordship challenging that particular that observation. My lord, some crucial facts of the case are that I am the plaintiff in the original case. I am the owner of the property. The property was purchased by me by my money in the name of my son, which is the defendant number one. My lord, defendant number one, by way of two registered sale deeds, has disposed of this property to defendant number 2 and 3. When the mutation application was preferred by the defendant number 2 and 3, I got to know that my property has been disposed of. So I immediately went to the civil court and filed a civil suit for declaration seeking this entire sale deed as null and void and non-operational against me, and a suit for permanent injunction that nobody should restrain me from my personal occupation of this property. My civil suit for declaration and permanent injunction was the entire nature of the civil suit. When the defendants appeared, they filed an application saying that this is not a suit of declaration, but actually a suit of cancellation of sale deed. You should have sought cancellation of sale deed instead of seeking declaration, and thus should have paid the entire ad valorem court fees as is on the instrument. This application of the learned trial court was, this application of the defendant was allowed by the trial court, and they directed me to pay the ad valorem court fees. Now, my lord, there are two questions of law on which this civil revision lies before your lordship today. Number one, whether in this particular matter, should I have filed for a suit of cancellation of sale deed or my suit of declaration is enough? The law is no more res integra, my lord. It is very well settled by the Honorable Supreme Court in multiple judgments, including a reported landmark judgment of Sukhdeep Singh versus Randhir Singh, decided by the Supreme Court in 2010. I would request your lordship to consider paragraph number 7 of this judgment. The Supreme Court explains in no uncertain terms of when to file a suit of cancellation of sale deed and when to file a suit of declaration. The Supreme Court says, where the executant of a deed wants it to be annulled, he has to seek cancellation of the deed. But if a non-executant seeks annulment of a deed, he has to seek a declaration that the deed is invalid or non-est or illegal, or that it is not binding on him. The difference between a prayer for cancellation and declaration in regard to a deed of transfer conveyance can be brought out by the following illustration relating to A and B, two brothers. A executes a sale deed in favor of C. Subsequently, A wants to avoid that sale. A has to sue for cancellation of the deed. On the other hand, if B, who is not the executant of the deed, wants to avoid it, he has to sue for a declaration that the deed executed by A is invalid, void, and non-est, illegal, and he is not bound by it. In essence, both may be suing to have the deed set aside or declared as not binding, but the form is different and the court fee is also different. If A, the executant of the deed, seeks cancellation of the deed, he has to pay ad valorem court fees on the consideration stated in the sale deed. If B, who is a non-executant, is in possession and sues for a declaration that the deed is null or void and does not bind him or his share, he has to merely pay a fixed court fee of rupees 19.5. It was at that time under Article 17(3) of the second schedule of the Act. But if B, a non-executant, is not in possession and he seeks not only a declaration that the sealed deed is invalid, but also the consequential relief of possession, he has to pay an ad valorem court fee as provided under Section 7(4)(c) of the Act. I would take your lordship's liberty to just summarize as what the Supreme Court is trying to say. My lord knows better, but I'll still make an attempt. There are two brothers, A and B. Brother A executes a sale deed to a third party C. If A now wants to say that I don't want to be engaged in this sale transaction or anyhow wants to challenge that sale transaction, he has to file a cancellation of an instrument dava. Now, the A has sold it to C. Now it is the person B who wants to file a civil suit challenging this sale agreement. He only will have to seek declaration. The Supreme Court also says that there is one more thing. If B is in possession and is only seeking declaration, then no ad valorem court fees will be paid. But suppose B is also not in possession, but he wants possession, then he will have to seek consequential relief of possession and will have to pay the ad valorem court fees. In this particular matter, there are now three undisputed facts. Number one, I am in the possession. I have pleaded it in my plaint. I am only seeking for a declaration that this sale deed is invalid or non-est because it is my property. So I don't need to seek cancellation of sale deed. I don't need to file a civil suit for cancellation of sale deed. My only relief is declaration. And I am entitled to seek declaration under Section 34 of the specific agreement. That is point number one, incorrectly adjudicated by the learned trial court. Learned trial court, without reading, learned trial court is saying that your relief of declaration is covered under the blanket of relief of cancellation of sale deed and you cannot avoid the payment of court fees. That is an incorrect adjudication by the trial court. It is not covered under the blanket. It are two separate reliefs. I am not the executant of the sale document, so I am not required to seek the cancellation of that document. I am merely asking the court for a relief of declaration that this sale document is absolutely non-binding on me. It is non-est, it is non-illegal, it is illegal. That is consideration. That is point number one that I have placed before your lordship. Number two, my lord, is that the MP Madhya Pradesh may specifically in the state of Madhya Pradesh under the Court Fees Act, a very specific, unchallengeable rule that is made. That is, if you want to file a civil suit relating to agricultural land in Madhya Pradesh, आपकी कोर्ट फीस के लिए जो सिविल सूट का वैल्यूएशन होगा वो 20 टाइम्स ऑफ लगान होगा. सो एनुअल लैंड रेवेन्यू को 20 टाइम्स मल्टीप्लाई करेंगे, यू विल कम टू अ civil suit ka valuation. So anyway, the court cannot direct me to pay the ad valorem court fees in any other situation, my lord, because this is an agricultural land. So these are on 2 points, my lord, on which I have placed this civil revision on before your lordship. That is my case. But requesting one humble request. It is a case where I am seeking reverse IR. I am the plaintiff. At least the civil suit should continue. What has happened by the passing of this order by the trial court is that now the civil suit cannot continue. I am requesting that the civil suit should continue and see its day in the court. The effect and the relief that I am seeking is the effect of the impugned order may kindly be stayed by this honorable court until the final disposal of this revision, and the civil suit should stay, should continue to operate, continue to ongo. IA number
Number 8.
Number 1, 2, 180.
Grateful, madam. Grateful. Much obliged.